All rise.
Kosovo Specialist Chambers is now in session.
Please be seated. Good morning and welcome everyone. Madam Court Officer, would you please call the case?
Good morning, Your Honors. This is case KSC BC 2020-07, the Special Prosecutor versus Hisni Gucati and Nassim Haradinai.
Thank you. Ms. Polici, any change in your team this morning?
No change, Your Honor. Thank you.
Mr. Rees?
Just one change, Your Honor. I'm not assisted today by Mr. Haradinai because of a medical appointment, but no other change to the team.
Thank you. Mr. Warboys?
No, Your Honour, it's the same as it was last week, and Mr. Carl Buckley remains on the screen.
Thank you. Good morning, Mr. Buckley.
Good morning.
I also note that Mr. Gucati and Mr. Haradinai are present in the court. We will start with the further cross-examination of the two SBO witnesses. The panel recalls the following. On December 10th, the panel granted the Gucati Defense request to further cross-examine witnesses 4841 and 4842 and ordered the Gucati Defense to limit its questions to the materials disclosed pursuant to decisions F413 and F435. The defense should be ready to explain the relevance of any line of questioning pertaining to these materials. The panel further recalls that for purposes of security, non-disclosure of the identity of witnesses, and the interests of justice, the defense was directed to conduct its cross-examination in private session. The panel also noted that it will, in due course, review the transcript and order reclassification if appropriate. Mr. Rees, you indicated you do not envisage cross-examination for either of the witnesses in all likelihood to take more than a half an hour. Mr. Warboys, we received your filing in which you indicate that you will cross-examine the witnesses only if any relevant issue is not raised during the cross-examination by Mr. Rees, and that in any case your examination would not last more than 30 minutes. We appreciate this information you've provided. We will also allow re-examination if the conditions for it are met. We will begin with Ms. Pumper, and we will follow with Mr. Jukic. Madam Usher, please bring in Ms. Pumper, the first witness.
Good morning. Thank you.
Good morning, Ms. Pumper.
Good morning.
Be seated.
Thank you.
Please remember that you took a solemn declaration at the beginning of your testimony.
Microphone for Your Honor.
Remember that you took a solemn declaration at the beginning of your testimony, and that still applies to what you will be saying in court today. The Gucati Defense has some questions for you about materials disclosed by the prosecution pursuant to two decisions of the panel. Mr. Rees will go first. Next, the lawyers representing Mr. Haradini may ask some questions as well. Then the panel may allow re-examination by the prosecution if the conditions for it are met and if requested. Lastly, members of the panel may also ask you some questions. I remind you to please speak into the microphone and to give a pause before answering a question to allow the interpreters to keep up with you. For purposes of security, non-disclosure of the identity of witnesses, and the interests of justice, the defense will conduct its cross-examination in private session. Madam Court Officer, can we please move to private session?
Your Honors, we are now in public session.
Thank you. Good morning, Mr. Jukic. Please be seated.
Thank you, Your Honor.
Please remember that you took a solemn declaration at the beginning of your testimony, and that still applies to what you will be saying in court today. The Gucati defense has some further questions for you about disclosures that were made by the SBO pursuant to two decisions of the panel. Mr. Reese will go first. Next, the lawyers representing Mr. Haradinai may have some questions for you, and then the panel will allow re-examination by the prosecution if conditions for that are met and it is requested. Lastly, members of the panel may also have some questions for you. Please speak into the microphone and wait a 5-second pause before answering a question so that the interpreters can stay up with you. For purposes of security, non-disclosure of the identity of witnesses, and the interests of justice, the defense will conduct its cross-examination in private session. Madam Court Officer, can we please move to private session?
Your Honors, we're in public session.
Once again, Mr. Jukic, this concludes your testimony. You may leave now. We wish you a good day. Thank you for being with us. Madam Usher, you may escort Mr. Jukic out.
Thank you, Your Honors.
All right, we'll move on. Mr. Reese, the panel received your indication that you withdraw witness 1247. You've had an opportunity to cross-examine the two SBO witnesses. Any further witnesses?
Unless Mr. Pache volunteers to give oral evidence and tender himself for cross-examination, I don't anticipate any further oral evidence.
Thank you.
There is the outstanding bar table motion, and I have a mea culpa to make. There is one document that I oversaw in both the evidence of Mr. Gucati himself and in drafting the bar table motion, which I'd ask the panel to look at very briefly. It's DHG 0496. And we have raised this with the SPO, and Ms. Bellici very helpfully has indicated that although there is an objection based on relevance, they do not object to me orally seeking to add this to the bar table motion, which they will respond to in full, including in relation to this document. It's a short document. It's a posting from the Husni Gucati Facebook account, for which postings have already been admitted through the bar table motion. It's dated the 15th of September 2020. It has the image that the trial panel may recall I asked Ms. Pumper questions about. The relevance of it, we say, is it goes to support Mr. Gucati's account in both his viva voce evidence and in the statement admitted under Rule 154 that in the run-up to the second delivery, by lightning strike 2, he became aware of, or suspicious at least, of being under surveillance. And the posting is dated the 15th of September 2020, and we say it supports his testimony to that extent. So we ask for that to be considered as part of the bar table motion. I'm very grateful to the SPO for their cooperation in that matter.
No objection.
Your Honor, although no justification has been adduced for the late request from the defense, indeed we do not object to the addition of this item to the exhibit list. We will object to the admission of the item and will be ready to respond on this item as well with our overall response to the bar table motion, which is due later today.
Thank you, Ms. Bellici. Thank you, Mr. Reese.
But there are two other matters then. In relation to the bar table motion, before we formally give notice of closure of our case, we would wish to see the panel's decision on the bar table motion and would request that the trial panel allows us, in the same way as it allowed the trial panel, for a direction to serve the formal notice by filing once the bar table motion has been received. It's purely as a matter of caution on my part that for us to allow, to consider at least, making an application to the court, if there is any aspect of our bar table motions that's not accepted, permission to call evidence in some other manner, whatever the likelihood of such an application being allowed to succeed is, I would still appreciate the opportunity to be able to consider that in due course.
Just so you know, we intend to have the decision on the bar table motion yet this week.
I'm grateful. The second matter is a matter which I simply want to raise so that the trial panel is aware of it. It won't hold up any matters. That's this. There are ongoing discussions about agreed proposed facts on controversial matters, we hope. Again, I stress that does not require any delay in us closing the case because, of course, agreed proposed facts can be admitted at any point during the evidentiary proceedings, including during the course of Mr. Haradinai's case. All three parties, of course, are required to agree those, and the evidence goes in the case as a whole.
Thank you for that information. Mr. Warboys, as for the Haradinai Defense, no separate bar table motion was filed by the deadline of December 10th. As I noted earlier, the Haradinai Defense joined the Gucati bar table motion. I didn't say that earlier, but I'm saying it now. Mr. Warboys or Mr. Buckley, whoever wishes to speak, we understand this to mean that the Haradinai Defense will not file a separate bar table motion. Is that correct?
Your Honour, that's correct. The joinder application was all that will be put in.
I also note that the Haradinai Defense filed 2 exhibit lists. The first was filed on 2nd of December 2021 after an extension of the original deadline, which was November 29, 2021. This is filing F469 with Annex 1. The second list was filed on 10 December 2021, further to a renewed order to file an updated exhibit list conforming with our order on the conduct of proceedings. This is filing F489 with Annex 1. What we now have are 2 almost completely different lists. The first list has 30 exhibits and no indication which of these are intended to be tendered with which witness, despite the panel's order that it should. This list is almost identical to the Gucati exhibit list, save for the last 3 items. The second list has 23 exhibits, of which 21 do not appear on the first list. For each exhibit on the second list, you indicate the witness, though, through whom you wish to tender it. You also request that these exhibits are added to your first list. Some of these have been disclosed yesterday. Before I ask you some questions on these lists, let me remind you of how this works. Under Rule 119-2B, the defense needs to file a list of proposed exhibits the defense intends to present. That means to use during your case and/or to tender for admission. Pursuant to paragraphs 60 and 61 of our Order on the Conduct of Proceedings, we also required the parties to indicate the witness through whom some of these exhibits are to be tendered. Our goal with this was to avoid the overloading of the exhibit lists with material that the parties will neither use nor tender during their case, and this was explicitly said in paragraph 17 of the Order on the Conduct of Proceedings. So with this background in mind, can you explain to the panel what is the role of these 2 lists?
Your Honour, my first point is if there are any mistakes or confusions here, that will be as a result of my decisions on this. The first list, my understanding, needed to be replaced under the order of this court, and an indication given as to which witnesses would be adducing certain documents. The second list, therefore, replaces and, in effect, is the list which this court should look at. To explain what the additional documents are, my understanding is that in respect of witness 1252, there will obviously be oral testimony. There are a great number of documents referred to which are, on one view, authorities, but in a technical sense, because this is an expert report, those documents have been added to our list under Rule 1192B, so that they can be adduced and the court can have sight of those documents. If there is a simpler or more efficient process by which the court would prefer to have those documents in evidence, I'm happy to assist. What I wanted to guard against and avoid was a situation where we have live evidence, but we don't have the necessary documents on the file, nor have the SPO had an opportunity to see those documents in advance or to comment on, for example, whether they are in fact the correct documents. That was the purpose, and it was purely with the intention of ensuring that when we get to 1252, it can be dealt with efficiently and without problems.
So as far as you are concerned, the second list completely replaces the first list, and we can disregard the first list?
Yes, Your Honour. We may at some point rely, obviously, on documents that have been tendered through the Gucati exhibit, but those, my understanding, are now effectively on the record, so they are fair game, to use a simple term.
So, Madam Prosecutor, or whoever wishes to answer this, do you have any objections to adding the new exhibits of the Haradinai Defense to their Rule 119-2 list as requested in their filing?
We have no objections, Your Honor, to this addition. We would seek, however, some clarity about which exhibits will be used with which witness as required in the order for the conduct of proceedings.
And can that be done immediately?
Your Honour, my understanding was that the list provided had indicated which witness the documents would be relevant to, and the new ones provided are all in relation to 1252. Where they are referred to in the report should be clear from the report itself, since in effect it's effectively a bundle of documents for the witness.
An inter-party discussion about this so that Ms. Bolici is clear and Mr. Reese is clear about what your intentions are. If there's a question about which witness and which exhibit, you can clarify that easily, all right?
Of course, Your Honour, I'll ensure that it's
Perhaps
clear
we
and
can do
agreed.
that yet today.
Of course, Your Honour.
Noting that the SPO does not object to the addition of the new exhibits listed in the Haradinai Defense in F489 Annex 1, the panel authorizes their addition in accordance with Rule 119.5, subject to this inter-party discussion on the witness connected to the exhibit, and bring it to our attention immediately if there is any unresolved issue. The Haradinai Defense is ordered to file an updated consolidated exhibit list by January 6, 2022, listing all exhibits intended to be used and/or tendered during the presentation of its case. For exhibits to be tendered through witnesses, an indication should be made of the witness through which the exhibit is to be tendered, and this concludes the oral order. One more housekeeping matter. On 23 November, the SBO filed proposed public redactions to a number of admitted exhibits. I'm referring to filing F445. Neither defense team responded to this filing. On Monday, 13 December 2021, the SBO submitted an amended proposal for the public redaction of one of the exhibits. The panel intends to decide on this request by Friday of this week. Do any of the defense teams object to the amended proposed version filed on Monday? Mr. Reese?
I don't think so, but would Your Honour give us some time just to cast an eye over it, and then we can confirm either in writing or
Can that be done
later
today?
Yes, absolutely.
Thank you. But let's make it by 4 o'clock to file a written document, or Mr. Warboys?
The same position if the court would be so
All right,
kind.
by 4
Thank you.
o'clock today, we will have a written submission on the one exhibit. We will now address the Haradinai request for adjournment. On 12 December, the Haradinai Defense emailed the panel seeking adjournment of the defense's case until the new year. On 13 December, following the panel's instructions, the Haradinai Defense filed a formal request seeking, first, the adjournment of the trial proceedings until January 2022, and second, extension of time to file Mr. Haradinai's witness statement. The Haradinai filing is F491. On the same day, the panel filed an order informing the Haradinai Defense and the registry that defense witnesses 1246 and 1254 were no longer expected to appear this week. The panel also informed the parties that it will hear any further submissions on the Haradinai's defense request today. on today's date. Mr. Warboys, or Mr. Buckley, you have the floor. Please also indicate whether you are in a position to deliver your opening statement today or tomorrow.
Your Honour, what I won't do now is trail over the ground that has been covered in the adjournment application and the email that was sent. What I will say, though, is that this filing was made in an open and transparent way, and there was clearly a degree of candid assessment on my part as to what was and was not possible, as I'm obliged to consider in my professional obligations. What I can update the court on since then is first that we are able and indeed can deliver an opening today, which will hopefully enable the case to progress somewhat. I've spoken to the SPO about this, and unless they say to the contrary now, they have no objection to the opening being delivered. In addition, in an attempt to assist with case management, if I may, I have spoken to the SPO and sort of mapped out a rough time estimate for each of the witnesses that may follow. I can give that to the court and give the proposal if it would assist.
It would assist, and we would like that.
In essence, and please, I haven't consulted with the Gucati Defense because it was late in the day, and of course the SPO can say anything if they disagree. I'd have no objection to that. But for Mr. Haradinai, we estimate half a day of evidence from us. We would be seeking to provide a statement and adduce that pursuant to Rule 154, but there would, of course, be additional questions, like has been asked in the Gucati case. The SPO, I understand, estimates around 10 hours, which, on a conservative estimate, takes us about 3 days in total. For witness 1246, 15 minutes, I think, would be sufficient with a Rule 154 application and 2 hours cross-examination. I should say there that we have endeavoured with the SPO over the weekend to provide some paragraphs which would not be read from this statement. Again, in respect to Mr. Gashi, we would say the same, that it would be 15 minutes under Rule 154 with 4 hours cross-examination. And there we've also sought to be pragmatic over the weekend and to identify some paragraphs that the SPO may well object to, and in the spirit of trying to agree and move this forward. And then on 1252, I suspect 2 hours would be sufficient for examination in chief. The SPO has informed me that they expect 2 hours approximately for cross-examination, which is broadly half a day. So while it might be a squeeze, and I don't want to create hostage to fortune, there is some scope that it could be possible to complete those witnesses within the 4.5 day slot in the new year. Obviously, if they do overrun, then that will be out of my control, particularly on the cross-examination side, but that would be the best that I think could be manageable in terms of active case management. One aspect of the application, clearly, which Your Honours will have seen, is in relation to the filing of a statement from Mr. Haradinai. Here on this issue, the reality, without wanting to disclose too much, is that there are logistical and practical challenges, particularly in view of my not understanding or not being aware and familiar with how many of the systems work, and also the need to clearly ensure that anything signed by Mr. Haradinai is correct and, in fact, his evidence. There, we would seek to file a statement as soon as possible, clearly. But again, what I really don't want to do and avoid is to give false promises to the court and be in a position where we're creating more problems. So in the interests of caution, I would say that if we can file a signed statement by a week today at 4 p.m., which is the 22nd of December, then that will be achievable. Particularly as I've learned, it's not possible to see the witness over the weekend in the detention centre. That date in our submission, it wouldn't give any material prejudice to the SPO nor the process of the proceedings at this point. Clearly it is not ideal in what was originally envisaged, but it is, with sincerity, I think the best that can be offered, Your Honour.
Does it assist if we give some indication as to cross-examination times for the Haradinai case as well? It comes with the caveat.
I'm sorry, for the record, yes, please.
It comes with the caveat, of course, that we will be looking very carefully to make sure that all matters are covered, and if they are, we won't take any time in cross-examination. But I think going through that schedule, we would ask that allowance is made, if necessary, for an hour in relation to Mr. Haradinai, 30 minutes for witness 1246, an hour for Mr. Gashin, an hour for witness 1252.
It's helpful, Mr. Rees. Thank you very much. And I take it you have no objection to the Haradinai request for adjournment?
No.
Okay. Ms. Bolici?
Your Honour, first we would like to highlight that we continue sympathizing with Mr. Kadman's current health condition and that we are looking forward to see him fully recovered and back in court. In relation to the application for an adjournment, we need to observe, however, that it attempts to establish a precedent that we cannot accept, as it would be contrary to the principle of efficiency of the proceedings as reflected in the statutory framework. The unavailability of a counsel, although for a compelling reason, cannot be invoked as a justification for the delay of the proceedings when there are two co-counsel available. The function of co-counsel is primarily to assist and ensure the continuity of the defense when the lead counsel is unavailable, and the temporary unavailability of a counsel is not an entirely unexpected matter, especially at the time of a war pandemic. The registry practice direction on counsel indicates at Article 18, paragraph 2 and 4, that in choosing member of his or her team, counsel shall take into account their experience and competence, and that chosen co-counsel shall have the authority to sign documents and to appear in court on counsel's behalf, dealing with all erasing matters. Furthermore, the application failed to mention that a second co-counsel has been involved in the case from the outset and has been in the position to attend all hearings remotely. Finally, we see no particular reason in the asserted difficulties in communication between the defense for Mr. Haradinai and the accused, considering that the SPO understands that the registry has taken all necessary measures to accommodate communication between the accused and co-counsel over the past days and weeks as and when necessary. We note that arrangements for the next two Haradinai witnesses have been cancelled, so we will not respond on this particular matter. In relation to the request for a third postponement from the Haradina Defense in relation to the indication whether a statement from Mr. Haradina is going to be provided and when the statement is going to be provided, we note that the defense has been on notice of its disclosure obligation under Rule 119 and 104 since the start of these proceedings, that the scheduling order of this trial panel of the 9th of November initially indicated the 29th of November as the date for the disclosure of such statements, if any, and that the deadline for the disclosure of such statement has been missed 2 times already. We understand that there is no obstacle at this point in time for Mr. Haradinai to sign a written statement if he so wishes. It is prejudicial to the SPO to receive such statement at a very late stage. In fact, it has already been a prejudice to the SPO to conduct the cross-examination of all defense witnesses so far, including the co-accused, without the benefit of such statement. Therefore, we would request that a deadline for the provision of this statement, if any, is set by the trial panel, and we would request that this statement be disclosed this week. Thank you.
Thank you, Ms. Bellici. Any questions from the panel? Go ahead, Judge Barton.
Thank you very much. I don't have a question, but would rather make a comment. First, I have to say that contrary to what was indicated in the request for adjournment, I don't have the impression that Mr. Warboys needs more information about this case. In case my impression is wrong, I would like to say, Mr. Buckley, that the panel expects you, and if possible, Mr. Kettman, to immediately inform your colleague, Mr. Warboys, properly and completely before the next trial session, before the next trial hearing. I hope this is clear, Mr. Buckley.
Your Honour, of course. Me and Mr. Warboys are in regular contact. There is no issue whatsoever with a refusal or reluctance to provide instructions to him, or a reluctance to communicate with him at each and every available opportunity. And that simply isn't an issue that has arisen at any time. The position we are in, unfortunately, is an incredibly unique position. I accept entirely that the ongoing pandemic has been with us for some near 2 years now, and there has been a number of significant effects. However, over the past couple of weeks, that situation has deteriorated and developed further, both specifically to the defence team and more generally across Europe. But again, to reaffirm, there is no issue whatsoever with communication or the provision of instructions between counsel.
I understand. Thank you very much.
Judge Metro has a question.
Thank you, Judge Smith. And the question is for you, Mr. Warboys, and I really don't mean it to be taken as a criticism of you. You have been of great assistance to the panel, and we're grateful for that. But I want to ask you what exactly is holding up the finalization of the statement of Mr. Haradinai. We have been given notice, I believe, on the 3rd of September of this year, that it was the intention of Mr. Haradinai to testify, and at that point in time I would expect that work had started on the preparation of that statement, and there was at that time no issue of access to Mr. Haradinai or access by Mr. Cadman to him. So simply to understand from you what is holding things up, whether it's still a matter of signature, so that indeed I think the prosecution has a point when they say that they should be entitled as soon as possible to a copy of that statement with a view to fair and timely preparation. So can you help us with that?
Of course. Judge Barth, if I may, just to say that your point is registered and heard and well received. Your Honour, I think the first point, and this isn't to make excuses, is I wasn't involved in the case back then, so I can't comment on back at the beginning, so I can't comment on what was happening at that time in any great detail. As to where we are now, the reality is I had tried over the weekend to get in contact with Mr. Haradini after the hearing on Friday when Mr. Cadman had deteriorated. My efforts to speak to him over the weekend didn't work because there's no opportunity, as I now understand, to speak to witnesses in detention over the weekend at the last minute. So that entailed a loss of several days. There was an updated statement which was sent to Mr. Haradini on Monday with the intention of going through it with him yesterday However, my understanding is due to the detention process, that statement didn't actually reach him yesterday. So, again, without wanting to divulge too much, I clearly tried my best to take instructions on the basis of not having a statement, but there's nothing that can be done without the statement being in front of Mr. Haradini himself. What I'm now proposing to do is to meet with him again tomorrow or this afternoon, if it's possible, with a view to printing out a statement, if that can be given to him, and ensuring he has a copy. But obviously there may then be some amendments that come back, and of course, because of languages, there is a translation delay. Then we hit a weekend if it's not done by Friday, and then we lose some more days. So it is, in that respect, logistical challenges, and it is my, obviously, as here now, in effect, conducting this professional obligation to ensure that everything is understood and is correct before it is signed. And that's not an obligation which I clearly take on lightly, nor one that I would want to be done in a sort of fast and loose manner at the last minute for the sake of a couple of days. And as I said, I will, of course, endeavour to get this sorted as soon as possible, but the extension to the 22nd has just been requested so that we don't end up in this position again. As to the point from my learned friend that there's 2 deadlines missed, I would say there's only one. I had said to the court on Friday that we would try to get this done by Wednesday. I accept that. However, at that point, Mr. Cadman's health really did deteriorate very rapidly. But more to the point, we then came up against these logistical challenges, which I hadn't budgeted for and planned for. I am very mindful that this is not a helpful situation for anyone to be in. And I am also particularly mindful of my obligations as the council. However, I do clearly have overriding obligations to the client that I must discharge.
Thank you, Mr. Warboys.
All right, that concludes all the questions for today. We will take a 1 hour or a little more than 1 hour break and come back and issue an order. And you can be prepared to make the opening statement at that time. Has a document or a copy of the opening statement been available to the translators?
Yes, Your Honour, it was sent last night.
Thank you very much.
Your Honour, if I may, just a minor matter in relation to the estimates for cross-examination that were reported by the Haradina Defense. We just would like to highlight that for 1252, in light of the material that has been recently disclosed and the apparent intention to tender all these materials through this witness, we would at this point reconsider the estimation to 4 hours with the view of keeping it as short as possible if there is no need to cross-examine for the entire 4 hours. Thank you.
Thank you, Ms. Bolici. Mr. Buckley, we hope you do convey to Mr. Cadman our hope that he is well soon. We are all conscious of his situation and feel bad about that, so please do that. One last thing, I just want, in the filing that came through or in the email last week concerning this adjournment, there was a statement made that the panel was under pressure. I want to be very clear that the only pressure that this panel feels on keeping this case moving is self-imposed. There's certainly nobody pressuring this panel to do anything other than to make sure that there's a fair and expeditious trial. And we've done our best to do that, and we will continue to do that. So we will be back in an hour and 20 minutes, and we will finish with the orders and be welcoming your opening statement, Mr. Warboys. Thank you.
Rise. All rise.
Be seated. The panel will now issue an oral decision on the Haradinai Defense request for adjournment of the hearing until 2022. There are 5 issues to address: the role and responsibilities of counsel, the responsibility of the panel, the opening statement, the statement of Mr. Haradinai, and the presentation of evidence in the Haradinai case. First, regarding the responsibilities of counsel. The panel wishes to make it clear that the absence of lead counsel from the courtroom or his inability to perform his functions due to ill health or other considerations does not, on its own, justify an adjournment under Rule 123. In this regard, the panel draws attention to Section 18, Sub 4 of the Directive on Counsel, according to which co-counsel shall have the authority to sign documents and to appear in court on counsel's behalf, dealing with all arising matters. There are 2 co-counsel in this case who have full competence to represent the accused and to act on his behalf and under his instructions. One of them is physically present in this courtroom and has done so far his best to advance these proceedings. The other co-counsel is participating remotely and is, as indicated earlier, is in constant contact with Mr. Warboys. So the panel emphasizes that the practical arrangements and division of labor set by lead counsel or agreed upon between counsel are not in any way qualifying the obligations of counsel towards their client or towards the panel. Second, the responsibility of this panel. As I said earlier, this panel is responsible for the fair and expeditious conduct of the proceedings as set out in Article 40 of the law and Rule 116. The panel is mindful that the accused are in detention and that any undue delay in the proceedings might affect their fair trial rights. So it is the panel's obligation to keep any delay as short as practically possible and to delay matters only where there is good reasons for it. Third, the opening statement. The panel welcomes the readiness of the Haradinai Defense to make its opening statement today and will hear it shortly. The panel therefore directs the Haradinai Defense to open its case today, 15 December 2021. Fourth issue, the request for an extension of time for the submission of the statement of Mr. Haradinai. The panel finds that the 2 reasons initially advanced by the defense, namely that Mr. Haradinai was in quarantine until recently and that key team members have been absent due to COVID-19, are unpersuasive. The panel notes at the outset that Mr. Haradinai's decision to testify was announced almost 3 months ago, long before any COVID-related issue arose in this case. The panel therefore assumes that the groundwork for that document was prepared and there was no request before the Rule 119 deadline for an extension of time to finalize this document. The panel also observes that Mr. Haradinai has been present in the courtroom throughout last week and had the opportunity to meet with co-counsel in person. The panel finally recalls that Mr. Haradinai and his defense team have had the possibility to arrange confidential meetings, whether in person, by phone, or by Zoom, since Mr. Haradinai left quarantine on December 8, and that these contacts can be organized and facilitated with the registry and the detention management unit. That being said, the panel accepts in this specific instance the submissions of Mr. Warboys about the difficulties in liaising with Mr. Haradinai in the absence of lead counsel. So the panel will grant an extension, the very last one, for submitting the written statement of Mr. Haradinai. While the panel notes the submissions of the SPO about the prejudice the delay is causing, the panel prefers at this point to set a more generous deadline so as to make sure that the signed document is finally filed and that no further extension is sought. The panel therefore directs the Haradinai Defense to file Mr. Haradinai's statement by Monday, 27 December 2021. The fifth and last issue is the presentation of evidence in the Haradinai case. While the panel wishes Mr. Cadman the promptest of recovery, it hereby informs the Haradinai Defense that the two co-counsels for Mr. Haradinai are expected to be ready to proceed with all the next stages of the case in early January, even if Mr. Cadman is not in a position to be present. The panel stresses that it considers the representation via co-counsel amounts to effective representation, and the absence of the lead counsel cannot result in affecting the efficiency of the proceedings. With this in mind, the panel orders the Haradinai Defense to submit by Thursday, 6 January 2022, a consolidated filing containing the following. First, any updates or changes to the witness list that is original filing F461 Annex 1, and also an updated consolidated exhibit list as we ordered earlier today. The panel grants the Haradinai application for adjournment and orders that the presentation of evidence in the Haradinai case will start on Tuesday, 11 January 2022. The panel expects the Haradinai Defense to be ready at that time to start with the testimony of Mr. Haradinai. The panel will sit from 11 to 13 January, full hearing days. On January 14, the panel will sit for 2 morning sessions. On 17 January, it will be a full hearing day. The panel will also schedule January 21, 24, 31 as additional sitting days. And this concludes the oral order. Mr. Rees, in relation to your submissions regarding the closing of your case, the panel notes that, according to Rule 131, the defense case is closed when there are no more witnesses to be called or other evidence to be presented as part of the defense case of any accused. So there is no requirement to close your case now, as the Haradinai Defense still needs to present its case. That being said, subject to the resolution of your application for admission of certain exhibits from the bar table, we regard your case as now having been presented to us. As we will approach the end of the Haradinai case, we will expect counsel to be ready to promptly and formally close the defense case by written submission. I believe Judge Matreau has a question for you, Mr. Rees, regarding the document you are adding to today's bar table, or adding to your bar table motion, the Facebook post. Judge Matreau.
Thank you, Judge Smith. And I actually have 2 questions for you, Mr. Rees. The first has to do with this document, which is DHG0496. That's the document for which you sought leave to amend your motion for the bar table motion. The question is about the origin of the picture on that document. Am I right to understand that this is a picture taken by your client, Mr. Gucati?
I obviously am not in a position to give evidence, but I can take instructions on that and assist it perhaps later this morning before we finish.
We'd be grateful, Mr. Rees. The second question, and it's really a matter of clarification, but your bar table application includes a number of press articles and NGO reports. Are we to understand you are seeking to rely on the truth of the content of these articles and reports?
We submit that they are from reliable sources. They're from well-known and respected agencies, both NGOs and newspapers. To the extent that their content is publicly available, as we have put it in the bar table motion, we submit that they make plain how one can reasonably conclude that the persons named therein can be reasonably described as enemies of the state of Kosovo, which has formed a significant part of the line of cross-examination of Mr. Gucati. And we say that those publicly available sources justify that description, irregardless of those named persons' status, if it is their status, as witnesses, irregardless of that.
So the answer to the question is you are seeking to rely on the truth of the content of these articles and reports.
And the fact that they are stated publicly. So it's both the fact of the truth, to the extent that the panel can give weight to what's reported therein, and I accept it's a matter for the panel as to what weight can be given to those sources, but not just to the contents, but also to the fact of those matters being reported publicly. I hope that assists. So it's the two limbs.
Yes, and if you can revert to us in relation to the picture before the end of the day, we'd be grateful. Thank you.
The panel will now hear the opening statement of the defense for Nassim Haradinai, pursuant to Rules 126 and 127. Before we start, for the benefit of the public, I recall that the panel held the defense preparation conference on December 2nd, 2021. The panel has already authorized the Haradinai Defense to make its opening statement after the end of the Gucati case. The panel recalls that in accordance with Rule 126, Paragraph 1, opening statements shall be made orally and shall be restricted to a principled overview of the subject matter of the case. They may also provide a concise explanation of the evidence to be called and how it impacts on the issues in the case. The presentation of evidence for the Haradinai defense case will start on Tuesday, 11 January 2022, and Mr. Warboys, you now have the floor.
May it please your honours, it is a privilege to appear before you in one of the first cases before the specialist chambers, a case in which the jurisdiction and appropriateness of jurisdiction imposes grave responsibility. Today, I am reading and delivering the opening speech of Mr. Cadman, who, as you all know, is unable to be here due to health conditions. Your honours, it is notable that courts try cases, but occasionally cases try courts. This is one such occasion. We have heard from the SPO as to the importance of this institution and how the case is about protection of individuals. We have heard this case is about justice, it is about accountability, and it is about the rule of law. The SPO is correct on each and every one of these points. However, conspicuous by its absence is any reference to the victims of the conflict at the hands of Serbian aggressors. The purpose of this institution is to bring justice to all victims. If anyone deserves justice, then everyone deserves justice. You may consider that it is not relevant to these proceedings. Mr. Haradinai, however, believes it is directly relevant, and it is a central part of the defence that will be presented on his behalf. The defendant, Mr. Haradinai, is in essence accused of crimes that focus on undermining the process of justice. He has been accused, in one way or another, of seeking to harm this institution. But none of this is true. Mr. Haradinai is not against justice. He is in favour of it. Mr. Haradinai has stated on more than one occasion that everyone who has committed a war crime or crime during the armed conflict should be prosecuted. He has stated that nobody should be shielded from justice. Moreover, when Mr. Haradinai became Vice President of the KLA War Veterans Association, he made one point very clear. That was, those persons being summoned should cooperate. They had nothing to hide nor fear. These are not the acts of someone who seeks to prevent justice. Rather, they are the actions of someone who seeks to secure it. Mr. Haradinai has dedicated his life to the independence and physical integrity of the Republic of Kosovo. He has been persecuted for much of his childhood and his adult life. He has been imprisoned, beaten, and subjugated, and now he is subject to these charges. The prosecution suggests that this is an open and shut case. However, it is not. Putting aside the precise details of the case for 1 second, at the centre of this case is the public interest, truth, inadequacies, and justice for all. The SPO in its opening speech draws reference to this case being about the building of institutions, building institutions that can protect those that assist it and bring justice to all. However, each and every one of the documents said to have been disclosed in this case and that form the centre of this case have come from the Specialist Prosecutor's Office. The defendants did not take those items. Indeed, in his opening, the Specialist Prosecutor confirmed for the first time that the documents were stolen and further confirmed that the defendant were not responsible for it. It follows that the SPO has had inadequate security measures, and that is one of the real issues at heart here. In addition, there are open questions as to how the documents came to be at the KLA War Veterans Association, whether the documents are genuine, among other questions. Those questions are all issues that the court will have to grapple with, but they are difficult questions to answer in a transparent and fair way, given the lack of documentation that has been supplied to the defence in this case, and the double standards that have been seen when it comes to the fact, for example, that Mr. Berisha has been said to not to have committed crimes, but the accused have. Mr. Haradinai has sought to expose the failures of the SPO, but the SPO has not sought to speak to him about his concerns. Instead, he has moved to be here today. One defining characteristic of this case is that unlike other trials before this court, it does not directly involve historical allegations.
Could the counsel please be asked to slow down for the purposes of interpretation? Thank you.
The SPO would have the trial panel therefore believe that history is not relevant to this case at all. However, that is not the case. History is relevant and it cannot be ignored. This is because it forms much of the context of the present case before the court. As to the history, which I will not dwell on because I'm mindful of prior directions of the trial panel, which, while we might not agree with, we are bound to follow. The recognised conflict in Kosovo lasted from 1998 to 1999. However, tensions, oppression, and calls for independence and autonomy long predate that, as do the massacres. There was immeasurable suffering by the people of Kosovo at the hands of the Serbian state, and this included Mr. Haradinai and his family. That same Serbian state now refuses to provide the people of Kosovo with the recognition they deserve. This history is recent. It is therefore at the forefront of the consciousness of not only a select number of individuals, but that of an entire population that this court represents and of which it is an institution of. A significant and, within some quarters, universal criticism of the KSE and its approach is that it is only targeting allegations made against the KLA. This criticism may be rejected by some, but that does not mean the criticism cannot be made. As Mr. Smith, Specialist Prosecutor, stated in his opening, such criticism is welcomed and is an entirely legitimate expression of free speech. During the SPO case, we have not heard that there are any investigations open into any offence committed by individuals who are not part of the KLA. Accordingly, and exercising the right of free speech, there would appear to be no investigation into the Maya massacre, where more than 300 Kosovo Albanians, many of whom were under the age of 18, were killed. There would appear to be no investigation into the Dretnica massacres, a region that suffered egregious and widespread abuses that Human Rights Watch has noted are well beyond the scope of discussion now. If our understanding of these investigations is correct, these massacres are not subject to the investigation of the SPO, and one must question why. Further, one must question why Kosovan civilians are being kept in the dark as to the fact that many incidents are not being investigated. This is not about an impunity gap. Mr. Haradinai has consistently demanded that all persons face justice. But to do this in a one-sided and mono-ethnic way perpetuates the theory of lasting impunity to the thousands of civilian victims. Turning to the specific facts and allegations in this case, the SPO are asking that this trial panel find Mr. Haradinai guilty of 6 counts of on the indictment, namely the following. 1, obstructing official persons in performing official duties by serious threat. 2, obstructing official persons in performing duties by participating in the common action of a group. 3, intimidation during criminal proceedings. 4, retaliation. 5, violation of secrecy. And 6, violation of secrecy as well. By way of preliminary observation, I will say that since the leak, it cannot be denied that there has been vigorous debate in Kosovo that has been sparked, including as to what has happened and what has been done. In setting the context for this case, it must therefore be asked, is there not a public interest in knowing what is going on? For example, is there not a public interest in knowing that the SPO are engaging with people who are the subject of Interpol Red Notice alerts? Mr. Haradinai says yes, but more than saying yes, he believes there is such a public interest in the importance of understanding what is happening and that the people of Kosovo deserve to know. Even Mr. Berisha, an SPO witness, would agree. It is also important to recall that Mr. Haradinai did not come to this realization after the 7th September 2020. It is something that he has sought to address previously. Before moving on to some observations regarding the counts themselves, and by way of preliminary observation as well, it's necessary to make 3 overarching points.
Is there a problem with the sound?
Your Honor, I understand there's no...
Po me përkthimin nuk më ndëgjoj. Tash po.
Okay.
Thank you.
Thank you, Your Honor. I was saying that it's necessary to make 3 overarching points. First, this investigation and or the case management has been fundamentally flawed. And when I say case management there, I mean the SPO investigation rather than anything before the court. I simply wish to say there's been no effective chain of custody, and the standards of investigation have fallen far below those expected of this institution. This is a point that taints the entirety of this prosecution and ought not to be glossed over. The defence will demonstrate that the prosecution was negligent at best in its investigations. Second, while Mr. Haradinai and his co-accused are alleged to have released the 3 sets of documents, the defence has not had access to those documents in their entirety, and the panel is expected to proceed in the interest of justice purely on the SPO's say-so. We have not heard witnesses or had any opportunity to challenge witnesses that make allegations that are central to the prosecution case. That is no way to conduct open justice and is a fundamental problem that goes to the heart of this case. Third, there is an inherent contradiction in the SPO submission that again goes to the heart of this case. Even Mr. Berisha, called by the SPO, noted the clear public interest in the publication of documents and maintained that his justification for publication was on the basis of a public interest. He has not been prosecuted for actions, which we say rightly so, and in that regard we would support the comments of the SPO at page 1507 of the transcript, that no crimes were committed. But if Mr. Berisha had not done anything wrong and has not committed any crime, how is Mr. Haradinai here before the court, having been accused of committing a crime? Mr. Rees QC, in his opening, summarised and drew reference to the evidence of Mr. Berisha, which I do not wish to go through now, but I would remind the court of that. At no stage has a media outlet been asked to remove the articles. At no stage has a media outlet been subject to any form of search. And there are journalists that still have copy of the documents, to the best of our knowledge. The question must therefore be asked as to why there are defendants before you today when others have been publicly deemed to have committed no crime, but took steps that went further and beyond those of the defendant. Moving to the counts, and by way of summary, and without prejudice to future arguments that we made. As to counts 1 and 2, Mr. Haradinai did not obstruct any investigation or the work of the SPO. Instead, the blame for any challenges that the SPO faced must fall squarely at their door. The SPO allowed the documents to end up at the WVA, either intentionally or inadvertently. Moreover, the specialist prosecutor confirmed without doubt that neither defendant was responsible for the theft or leak of those documents. The public interest is also firmly engaged, and there is no evidence of obstruction on the present facts in any event. Count 3 alleges that Mr. Haradinai has intimidated witnesses. Mr. Haradinai denies that he sought to intimidate any individual or did so. And more to the point, the SPO has not adduced any evidence to substantiate this charge. Moreover, the trial panel has been prevented from hearing or scrutinising the evidence of the witnesses themselves who lay foundation to the claim of intimidation. Instead, the trial panel is being asked to take the SPO's word, and it's heard limited evidence of what there is and what happened. That, in our submission, is not enough. In any event, when the notes of contact that the SPO made with witnesses are read, it is clear many individuals did not express concern for their safety after the leaks, but instead expressed concern that the leaks happened by the SPO in the first place. They also inquired as to whether what had happened was being investigated. To the extent there are problems, again, these must be attributed to the SPO. Mr. Haradinai does not shy away from the fact that he has been vocal in his criticism. But, again, as the Specialist Prosecutor, Mr. Jack Smith, has said, criticism is acceptable. The evidence to be called on behalf of Mr. Haradinai will demonstrate that no threats were made against protected witnesses or victims of any crime, nor was there ever any intention that such individuals should be targeted, but rather that Mr. Haradinai highlighted what had occurred and drew attention to it, acting in the course of his civil duty. The SPO seeks to use terms such as liar and traitors to strengthen its allegations. However, to understand Mr. Haradinai's remarks in their entirety, rather than carefully selected segments of quotes, one must understand his words, how they were actually used, and who they were directed against. Those were the people that orchestrated massacres and people that are wanted by Interpol. Count 4 alleges that Mr. Haradinai retaliated. As with Count 3, there is no evidence of retaliation. In any event, Mr. Haradinai is clear in his position and will be clear in his evidence that those investigations, those alleged to have committed offences, he would support the prosecution of. We will hear in particular how Mr. Haradinai changed the position of the KLA War Veterans Association when he assumed the vice presidency and ensured that individuals cooperated with the KSC where they were called to do so. Mr. Haradinai, by his own words, supports the pursuit of justice and accountability and supports a process that is fair and transparent. In short, his evidence will demonstrate that he supports justice. Mr. Haradinai has not retaliated, nor has the SPO at any stage identified people that support this charge. Count 5 suggests that Mr. Haradinai violated secrecy of proceedings. This is refuted. He was wholly unaware as to the documents in his possession were genuine, and the SPO has not proved that they were genuine. This is a fundamental problem. Regardless, there was a genuine belief, and his evidence will show this, that he had no option but to act in his way, and he acted in the public interest. Finally, Mr. Haradinai's evidence will demonstrate how he attempted to raise his concerns with the government, with the international community, and with the media, how he raised concerns with a number of individuals, and yet they all went unanswered. The concerns therefore remained, but no acknowledgement had taken place. Count 6 is similar to Count 5, and I do not intend to repeat myself. However, two salient factors have to be considered. First, and as Mr. Haradinai will confirm in his evidence, there are a number of individuals whose cooperation with the KSC and SPO is in the public domain and is well known. Certain of those individuals have even publicly disclosed that position themselves. The information is not secret. Second, Mr. Haradinai has been publicly clear that he requested names were not printed and that any disclosure was in the public interest. Your Honours, to close, the SPO has presented what it seems to consider is an open and shut case. The reality, however, is very different, as we've seen from the evidence that's been offered thus far. Mr. Haradinai is not guilty of the offences on the indictment, as alleged. Mr. Haradinai was justified in what he did, and he was justified within the law. Thank you, Your Honours.
Thank you, Mr. Warboys. It is now time to wrap up for today. We will resume on Tuesday, the 11th of January, 2022 at 9:30 a.m. to start the presentation of the evidence of the Haradinai case. I want to thank the interpreters and translators, the court reporter, the security personnel, and the audio-visual personnel for your help today. This concludes today's public hearing. The hearing is adjourned.
All right.